We are live and recording.
Okay, welcome to the appeals court. I'm Justice William Mead. This is case 23J 176-278 Whitenson Street LLC versus Linda Walls. Okay, Ms. Walls, you're going to get the opportunity to speak first, and you will do so uninterrupted, and then I'll hear from Attorney Kearns and let her speak without interruption. So go ahead, Ms. Walls.
Thank you. With regard to the, do I speak to the money issue?
The only issues before me are you have to speak to your indigency, which I'm going to tell you up front, we're going to accept the fact that you're indigent like the trial court did. So the only issue that you need to speak to are your non-frivolous defenses to the eviction, okay?
Okay, thank you. So with regard to that, the rent being applied in the judge's ruling, Mark Camacho does the repairs, and he never repairs anything. He repairs it in a manner that he gets to come back and just do it over and over. And I've noticed this for 10 years, not just at this property. It's just how he makes money. One of the ways he makes money. So, and currently, I messaged him. There's an ongoing issue with the front exterior door. When you come in, it doesn't hold the lock, and I had to kind of like lift. He has it shimmied with paint stirrers and whatever he does to make the door close. And so that issue comes in and out of play, and it just came in to play again recently. And he just does barely a Band-Aid fix. And
is this Ms. Walls? Excuse me. Is this an issue that you raised at trial?
Well, I didn't know rent was going to be applied.
It's a function of the appeals bond process. But before me, you can only raise defenses to your eviction based on issues that were raised at trial. I can't hear things myself for the first time.
Okay. So all the paperwork that was submitted to me, there's just flaw after flaw and defect after defect. And I know that some of the issues, Tina Kearns has said that the date, the 20th, she said, well, I knew I was going to see her the next day, and that she would give me the papers at that point in time. Well, that date should have been reflected. And I'm not nitpicking at a particular date. It's in everything that I receive. There's wrong dates. There's no proper name. And I received 5 summons and complaints, 5 with different dates, and then no proper name at all. I mean, it's sloppy at best. And then I'm the one who has to, and I'm not saying my paperwork is award-winning. I certainly understand it's a challenge. I have multiple pinched nerves in my hand, and my penmanship is horrible at best. But it's hard for me to make sense of what's keeping track of dates and all that sort of thing. And when I look on calendars, I find, okay, well, that was a holiday, that was a Saturday, that was a Sunday, that was and it makes it a challenging situation for me, more challenging to try to keep all the dates. And then I have to, even in court, at the trial, when the judge kept saying that I had filed something, I said, no, I tried to. And Tina Kearns stood there for like 3-4 minutes before she finally said, oh, that was me that filed it. So I said, I didn't file. I said, I tried to file something and they wouldn't let me. So
Ms. Walls,
finally,
can I?
Yes.
So you did receive the notice to quit in the summary process summons, though, right?
By manner of somebody knocking at the door, and then they went to the door next door, and I don't know who's the manager, this Jamie Brown or Mark or what.
But,
So
but you did receive it,
heard
right?
her.
That's the bottom line.
But the point that I'm trying to make, Your Honor, is that only by chance, because she was there, she opened the door and gave verbal directions. Otherwise, I would never get anything. So, I'm sure there was contact between Mark and Jamie, like, hey, he's going to come, you got to let him in, so that's how that came about. I didn't like not open the door, but it is an unidentified unit. There's 2 units that are unidentified, whereas out of 2 out of 5 there's no marking whatsoever. So, and the judge said, well, to apply logic, 1A, 1B, well, then the next door that's not marked would be 1C if you applied the logic that she said. And that's not how it plays out. The next one over is 1C, but there's no marking whatsoever. But I understand what you're telling me. Hey, you did receive it. Like I don't care if it's marked or not, is how I'm receiving it. It's that you received it. But
right. Is there another defense that you wanted to speak to this morning?
Just all plus I've had, and I think it's reflected in, I did tell the judge that I was hospitalized twice for COVID. And then I was hospitalized 4 times for blood transfusions. And then the end of September, I had major surgery. So it's in what, and then my mother was taken off a ventilator in Pennsylvania and she passed. So it's, trying to manage all of that, plus, this eviction, and trying to recover from major surgery and blood transfusions and iron deficiencies. And then my eye too. I'm trying to remedy what's going on with my eye. It doesn't open and close all the way. It tears all the time. It's been like way too much. And I did ask the judge, I said, would you please, give me time? And it was in, I didn't know what her decision would be, but I didn't, at that time, I didn't know what her position would be. But then afterwards, when I received her writings, it said that, a couple things. It said that I came to Massachusetts because of Mark. Well, I certainly didn't do that, and I certainly didn't say that. And then it also reflected that when she asked me if I needed more time, in quotation marks, it said no. I did ask, and I explained what I just explained to you too. I mean, these weren't like I had to go to the emergency room and get 2 little stitches. I mean, I had major bleeding out and just a whole host of things, and still, my eye thing going on, and other appointments. And I think that, I don't know if you received the letter from my primary care physician.
Was it before the judge at trial?
I gave it to the judge, and I think she denied it. I can't remember, but I think she denied it. She wouldn't take it. But everything else that was filed that day, from the other side, reflected as though I had filed it. In fact, I did not. It was the other side, but that was accepted. And the same as the other thing, the mailing that I wanted to file. As a matter of fact, I didn't even get a chance. I walked in and literally very animated, hands were thrown up in the air. We're not dealing with this. You can't do. So I was denied, and they said, just give it to the judge. And when I went in, the judge denied it. And so it was really difficult for me to try to, represent myself on anything.
Okay, I think I understand. Is there anything else you want to tell me relative to a defense?
I would like to say that due to lifelong allergies and stuff, I've been very overwhelmed with perfume scents and stuff. So I am very dizzy right now and short of breath. And even the cab ride from the ferry, there was all kinds of sense in there too. So I am feeling, not great. So
Okay.
I just,
I'm gonna
Okay,
give
thank
Attorney Kearns a chance now. Okay, Attorney
thank
Kearns.
you.
Good morning, Your Honor. Just as a quick background, this tenant has been staying in the apartment since June 2019. Initially, she was reluctantly invited into my client's apartment because she was homeless at the time. She had been evicted from another apartment, and my client felt bad for her. They were kind of friends before this whole thing happened. But it was meant to be a short-term situation, a short-term visit, a short-term stay. Over the period of years, my client kept continually asking her to leave because she wasn't paying any rent or any utilities. And apparently she had done that with other landlords in the past.
Okay, can you speak to the defenses, please?
Oh, I'm sorry. Okay, so as far as the defenses, she was served a notice to quit, a 90-day notice to quit on August 1st, 2022. It was served on, it was dated August 1st, 2022, and she was served on August 3rd, 2022. That was the one that was filed with the court. The summary process was served November 28th, 2022. So I know she said she was confused. There was maybe one or two evictions, 90-day evictions that I had sent to her prior that I thought that should have been worded better because I know she's very good at this type of stuff. So I wanted to make sure that it was absolutely perfect when I sent it to her. And so she actually got extra time living in that house. But the one that I ultimately filed was filed on August 3rd. And
Has any use and occupancy been paid as of the first of this month? Okay, go ahead.
We have not received any payments, not for the bond, not for the use and occupancy. So during the trial, she never offered any type of evidence whatsoever. She filed a motion to file her answer late. The judge denied the motion to file the answer late as far as the counterclaim. So she struck the counterclaims and she struck the jury trial. And so she was allowed to proceed on her defenses only, but she had no exhibits for her defenses. She produced nothing, no pictures, nothing about the apartment, like nothing. Then when during the trial, she also admitted receiving all, the notice to quit and being served the summary process. During the trial, the judge, between the judge and the tenant, they also established that her apartment is on the only apartment on the second floor. So it's the second floor. So I know she says it's not labeled and all this, but it's the second floor. It's the only one on there. It's a 4-bedroom, pretty large apartment that my client was living in. And before she came in, he was living in there, and he was, he'd go by there once every so often after he got out of work to fix it, because he was fixing it up so that he could rent it out. He manages property for a living and he owns them. In any event, the tenant, it was supposed to occupy one room on a short-term basis, but now she's occupying 3 rooms of that unit. During this time, while we were in the process of eviction, I had mentioned to my client, do you have a smaller apartment that you could put her into? So at least you could finish the 4-bedroom and then rent it out, because he could make close to $2,000 a month.
Please stick to the offenses that have been raised.
Okay, so and then she talks about the hospitalization and all of her medical issues. And she had presented, I believe, during the trial, it was a letter from a doctor. I objected to it because I felt there was no relevance. And so the judge had asked her point blank at one point, because Miss Wallace had brought the doctor's record up in all her medical issues. The judge had asked her point blank at one point during the trial whether or not she was looking for additional time. And she said no. So now she's saying that the judge never even gave her a chance or never considered the medical evidence, which I even think that the medical evidence is irrelevant. She's been living there since June 2019. And now I think she's just looking for extra time and an opportunity to relitigate her issues.
Okay. Is there anything else relative to the defenses you want to tell me?
we don't argue about the indigency, but I just think that she does not have a non-frivolous defense.
Okay, I understand.
Okay,
Okay, I will thank you both. I will take this under advisement.
thank you, Your Honor.